An important case from the Fifth Circuit Court of Appeals regarding arbitration.
This is Dr. David Schein, and welcome to Business Law 101.
There was a significant ruling by the Fifth Circuit Court of Appeals. The case is called Cure and Associates PC versus LPL Financial. Many of these financial organizations, to do business with them, especially in banking and finance, consumers and business associates are required to sign arbitration agreements in order to do business. And arbitration is where the parties have a private judge to resolve a dispute rather than going to court. The plus side is often faster and ultimately less expensive than going to court. However, some plaintiff attorneys do not like going to arbitration since they do not have the opportunity to go for a big jury award. In this case, Eileen Cure, who had her own investment firms, entered into agreements with LPL Financial to act as a registered broker representative under LPL's broker-dealer umbrella. This is a very common situation, and indeed, there was an arbitration provision. LPL and Cure got into a dispute, and LPL terminated her broker-dealer relationship. This is a big deal since she could not trade securities for her clients until she's associated with another broker-dealer. In turn, Cure, along with her companies, Cure and Associates PC and Premier Wealth and Retirement Management LLC, filed claims in court against LPL. The twist here is that Cure's companies were not signatories to the arbitration agreement. She claimed business disparagement, among other things, against LPL. In turn, LPL went to court to compel arbitration. Well, the U.S. District Court required Cure to arbitrate, but not the two companies that Cure owned. This, in turn, was appealed by LPL to the Fifth Circuit. That court reversed the district court and ordered arbitration for Cure and her companies. The basis of the decision was something called equitable estoppel. Basically, her companies were really part of the deal between Cure and LPL. So to separate her companies and let them litigate while she was arbitrating would simply not make sense. She was therefore estopped from trying to keep her two companies out of the arbitration to resolve her complaints against LPL. Yes, I'm not lisping. The word is E-S-T-O-P-P-E-L, estoppel. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.